numbers instead of identifying.
Are we allowed to add stuff?
You can do whatever you
Hold
want.
on, I'm still working on it. Stream, 1 second.
You lose it.
Okay.
I know I talked to Lori, but we can make.
So
notes
let us
on all
know,
of
Jason.
these, Put sticky notes in and everything else.
I don't think they care what you bring in at all.
I brought in all my school notes with me.
Candace gave us a huge packet of legislation. I brought all of it because I didn't want to keep it at home anymore.
Yeah.
So I used that as a dump
I
site.
already got it.
Whatever you take in has to be.
I'm not bringing all Candace legislation because everything, all the tests.
Okay, so I see the stream is up. I've got it here. I've just force refreshed all the audience players.
So if I read a statute once, I
they
can
should be
read
able
it,
to
I know exactly
see it
what
now.
I'm looking for. So for me, that was faster. To be honest, I didn't finish the materials. I didn't read them all. But
Yeah, we're back.
I was very
Okay.
prepared to be able to see it.
That's scary.
So Jason, we're back?
Yeah, looks totally good. I'm just looking on the chat to see what people are saying. It looks like it's up again. So I'm not sure honestly not sure what happened there. I'll have to run a report. Sorry about that, everyone. Enjoy the rest of the class.
I have to unplug the plug there, and then I'm gonna bring.
Yeah, they're like,
No, I have an idea.
they're like,
Do it. Let me try
the
something.
UFO mothership.
You take the UFO on the bridge.
Yeah, they're like the mothership. They can control everyone.
Those stuff that you interested in.
So like each legend, there's like a check because I failed.
Okay, so the content's back
When you
there.
go through, honestly,
Good.
don't answer every question. If you don't know the question, go to the next question. And
All right, so we're good. And
come
Jason,
back at the end.
you're getting content to your end? You see
Correct,
content
everything's
there?
good. You're ready to go live. Thank you.
Sorry,
Then wait
we're
till
back.
Yeah.
We troubleshot it,
We're
and we're done. Okay.
Okay, well, that's it for tonight. Everybody have a great day. Okay, so, I don't know where we cut out. Did we get feedback from the crowd on this question?
We started two,
Did we cut out with
Here?
John?
and then it was around over here. Yes, is it John?
Okay, so we had a few.
My short-term memory is kicking.
Do we,
Yeah.
oh no, I just didn't know if the audio or whatever had cut out before we got all of their answers in.
Why don't we get the answer again? John, do you want to give your explanation a little bit, and then we can continue?
I was saying that I feel the employer would have been correct in this situation in offering those forms of accommodation, primarily because they did give the employee options to choose from, and it didn't put him at a disadvantage compared to the other employees because he still did get his religious holiday off if he so chose. That was mine.
Now, Valerie also brought up undue hardship, which I'm going to come back to later on. Do we have any answers to what do you think online before I move on? Okay, perfect. So John is absolutely correct. If you can go to the next slide. In this instance, this is a real case. The employer was found to be correct. The board found for them. They said that providing a menu of options was enough.
Keep going.
Yep. Can we turn off the volume to
Well,
stop that from happening?
probably, but I don't want to do anything that might
Okay.
cause more problems.
I'm really
So,
sorry,
I'm
everyone.
gonna use-
I had my computer on mute when I did this presentation, so I didn't even realize that was in there. So the Ontario Human Rights Board did fine for the employer, and there's a few points under here. And as I mentioned, offering a menu of options was found to be sufficient. So I have another, what do you think? So I just want to get some group feedback throughout this. Some of you may have read this case. Lane, aged 50, was hired by ADGA, and he worked in manufacturing of military software. He had a bipolar disorder, but he did not disclose this information at the time he was hired. 4 days after starting work, he informed his supervisor that he may have an episode where his spouse would need to be contacted. I believe it was 9 days. I'm going to double check. Yeah.
Oh, keep going. Yeah.
Yeah, sorry, the 10th day of work, he received an utterance of a death threat from someone that he was dealing with, and that led to an episode. So the employer ended up firing him, and I'd like to know if you think that that's okay. Yes.
Is bipolar considered a disability?
I don't know. Is it?
I would think so. I don't think you can just fire people because they had a mental health issue while on a job.
Okay. Yeah.
But he did not disclose this when he was hired, so it has to depend what his application stated if he was of sound mental health at the time.
Yeah.
Well, aren't you not allowed to deny hiring somebody based on bipolar either? So even if you did disclose it, they
Very
wouldn't be
true.
able to change their...
But then it would have been down to deciding if, still hiring him, but being prepared of having other people, hiring maybe somebody else too, in case he was taking off time. Or training somebody in case there was an issue.
So you feel that he should have disclosed that upon hiring, ultimately?
Yeah.
Okay. Everyone's kind of in agreement with... No? Okay. Good. Okay, let's get some other feedback. Colin?
I don't think
This is my business partner, by the way.
I don't think you should have to be required to disclose all your medical personal information to get a job. I've never had to do that to get another job. I don't know why this gentleman would have to. Like you mentioned, it's discriminatory if they refuse to hire him because of a medical condition anyway. But all that aside, I think in this situation,
Don't give it away.
you can't just go right to the end and fire him with no investigation. They didn't contact his wife, his doctor. They didn't take any of the middle ground steps they could have. So I won't say anything else, but...
Yeah.
I would disagree respectfully, because in this instance, it's a little like somebody who's afraid of fire, becomes a fireman, and tells his boss, I can't go into that burning building because I'm afraid of fire.
But he was hired to develop software.
Nonetheless,
So-
if he's in a situation where he's accepted a job that he knows that he can't realistically do without causing a problem for the employer, and he doesn't disclose it, then no discrimination in my mind is occurred.
Okay.
I guess following that logic though, wouldn't that suggest that he would be able to be fired from any job because it never says that it's his position that causes him to have an episode. He's just has bipolar. He'll have an episode probably no matter what job he's working.
Okay. Did I see a hand here? Yeah.
If the employer didn't give that reason, there wouldn't be a problem, but their reason dictates that they can't do that.
Okay.
If they gave any other reason, they just didn't like his personality in the workplace, he was a downer or something.
Okay. So I didn't mention this, but if you read through, it actually says that the employer, after being informed that he may have an episode of bipolar, did research it on the internet. So they did do a little bit of research to find out how that would affect him. Yeah?
I was considering the employer, even after they did the research, they should always come up with something to accommodate that a person with a disability. They didn't even try.
Okay.
So I think that's a problem.
And I saw John's hand, so I'm gonna give him
So even if they did give a different reason on a balance of probabilities, they'd still be able to look at the variables involved and see if they were able to say on the balance of probabilities that he was terminated because he's a downer, then that would be a different story. But in this set of circumstances that are put before us, especially seeing as they were informed and then they looked at what is the potential risk for us or the liability to us in having somebody with bipolar disorder, on a balance of probabilities, they're still going to say that the nexus exists between that and his disability. Overall, I really like what Colin had to say. They didn't follow with the Human Rights Code, they have to look at any forms of accommodation that are reasonable up to the point of undue hardship. So like Colin said, they didn't inquire, they didn't speak with his doctor, they didn't talk to his wife, they didn't take really any proactive steps to try to see if he can do this job. So I really like what Bill had to say though, that if he was taking a job that he knew he wouldn't be able to do, then you might be able to have an issue there. But really, they didn't establish that he wasn't able to do the job. They didn't do a full inquiry to find out if he would be able to do the job. Instead, they just terminated it. So in my opinion, I would say they were way out of line.
Teresa, I saw your hand.
Additionally, by doing the research into bipolar, they are inferring what his bipolar will be like by comparing it to another bipolar person, and that is extremely discriminatory.
Fabulous,
You
Teresa.
can have one blind person that you need to accommodate with Braille, and the other one you will need to use voice recognition. application software.
I used the example earlier today of I have a tumor on my toe and you have a tumor in your brain. Apples and oranges, very different. So I'm going to go to the next slide here. I think you're going to click once and then go, and I'm sorry if there's noise.
The question, finish the code? Do you want?
Yep, no, you can go to the next slide. So the board found for the employee, the employer did not conduct any form of investigation. Their assessment of bipolar disease was absolutely outrageous, and he was awarded general damages, mental anguish, and loss of earnings, which is a big win with the APTO. So we're going to move into accommodation. So I think this case was a pretty good lead into it. Accommodations are things that can be done to prevent someone with a disability being disadvantaged. So in a store, that may mean that you have to lower the items on a shelf, widen the width of the aisles. In employment, it may mean that you need an ergonomic desk, or sometimes you may have to patch together a different job. Next slide. And the need to accommodate hinges on these three key elements. So it's individualization, so as Teresa pointed out, having one individual with bipolar, they may not have the same type of disorder that another individual does. The respect for the employee's dignity. So saying, well, you're in a wheelchair and we don't have a ramp, but you can get out of your wheelchair and crawl up the stairs, you're not respecting their dignity. And inclusive design. So inclusive design brings us back to constructive discrimination, which I mentioned earlier, which would be designing a policy that hits everyone but negatively impacts others. So inclusive design means that everyone has to be taken into consideration. And with inclusive design, this can actually include individuals who don't even work for you yet or who may not attend your store. So as I mentioned, wider aisles and things like that, that needs to be thought of before the store is built. And these are just some of the examples of accommodation, and this is nowhere near a full list. It could include accommodating different dress codes. You have RCMP officers who are allowed to wear turbans and their badges just pinned to the front. There are a number of different, and I believe there was an individual in the Army who had a special helmet built to accommodate the turban. So a lot of different things can be done to accommodate, and it really does take a lot of work on the employer side, because the burden does lie on them to make that accommodation if requested. And sometimes even if it's not requested, I'm not going to get into that today. So Kat mentioned earlier WISIA and undue hardship. It applies with HRTO as well. So the onus is on the employer to establish undue hardship, and it's based off of three major factors. That's the cost, so the monetary cost to complete the project, outside sources of funding, so whether you're eligible for grants or bank loans, and the effect on the health and safety of others. So if you are in an industry where you have a religion that forces you to wear very flowy clothing, but that could get caught in the, what do they call the belts?
Yeah.
In a factory, then that would be a potential for undue hardship. This is not an estimate or a ballpark, though, and this is very important. An employer they do have to do a very thorough investigation. They aren't able to just say, well, we think it's going to be about $10,000 and we just can't do it. It really does have to be very, very thorough, and in some instances it has been decided that a task force was required. And this is just an example of some of the remedies I'm trying to roll through. This is my last slide, so we're good. So these are just an example of some of the remedies that are provided. You have public interest remedies, which would be retraining or like sensitivity training. You can have that pushed for the entire workplace. General damages, this is what we call the DFSR, for your dignity, self-respect, and feelings. And restitution, so at the HRTO, you go to small claims court and it's not a court of equity. They can't give you your car back or even an apology. The HRTO, they can. They can give you your job back. There are instances where people have been out of work for years and been put right back into their possessions. And they can give you interest, but there are no cost awards here. And just as a final note, for appeals, there are none, but you can do a judicial review. And that's it. Do you have questions? No? No?
Beautiful.
All right.
Thank you. All right, thank you very much. We are going to start in 15 minutes the criminal and the POA. And just a couple things that I forgot at the beginning. Online people can ask questions, and we have had a few. Also, the questions from the WSIB that Catherine was reading from, they will be uploaded to the site. And Lon will also upload the PowerPoint that I emailed out earlier. There is a social afterwards tonight, and that is at the General. It's at 21 Salina Street in Oshawa. And last but not least, the raffle is Abby Donaral. Oh. So congratulations, raffle number 1 for prepnetwork.ca with Elaine Page. Okay? So congratulations. Yes, certainly.
We actually can give a phone number out to the viewers, so after the break, they can call their questions in and we can hear their voice while they talk to the class.
Okay.
Okay?
Okay.
This is a new thing where it's like call the rate, call the
After
radio.
the break?
We'll do it after the,
Okay.
or do you want, are you breaking now?
Yes.
You are, okay, we'll do it after the break.
Okay.
First time call or one time?
We'll break until 7:30. Abby, all you have to do is...
Jason, can you put the holding slide up for 15 minutes?
Just go on Prep Network. Yeah, and if you have any problems, email me.
Or Brian? Who's on?
What do you have to watch?
Oh, who is it? Brian or Jason? Jason, put the holding. We're on a break for 15 minutes. Can you put the holding slide? Or actually, I'll just mute. I'll just mute.
I can put the music in there. Yeah, just mute.
Yeah, just it's fine. Could you send me the number, or actually on the chat? Could you enter the number that the live stream viewers can call to call into the class with their questions? Because I'd like to do that after the break. We'll send out that number.
Good.
Could do that would you be able to do that?
Okay. Yeah, I'll do that right now.
Thanks. Perfect. Thanks.
Thank you. Bye.
What's that?
I'm supposed to be getting a refund. French lesson. Master.
So the mic is on.
I'd like to welcome everybody back.
I ask you to take your seats.
We have Frank Alfano and Danielle Basterach. She is filling in for Christina McDonald. Presenting provincial offenses and criminal. In between, just so that we can keep on our time, in a half an hour we'll be announcing the second raffle winner, and that will be to Frank and Christina's Law Society prep course. So I'll leave it in your capable hands. Thank you very much.
Thank you. Raise your hand if you are writing your Law Society exam this August. Okay, so quite a number of you.
So we want to win.
I'm going to
20
get
online, Frank.
20 online. Okay.
20 online.
Okay, so I'm going to give you some pieces of information that's going to help you put together finding the right answer. The Law Society exam is a multiple choice test, which means there's going to be a couple answers you're going to obviously avoid, and some of them that you're going to be torn to what appear to be correct answers you're going to be torn between. So let's just go to basics. Everything comes down to first principles, especially when it comes to stuff like POA. So who can tell me what year was the POA? What year did it come up? No one's going to know this, right? No. Of course not. It's 1979. It replaced summary conviction procedures for a simplified method. Simplified is an important word because it's essentially like a criminal court, except it's got some fairly relaxed rules. So, but there's going to be a lot of similarities between the criminal aspect of your exam and the provincial offenses aspect of your exam. So, we're going to start with the number one question that'll make you think about stuff. I need to hear 10 differences between part 1 and part 3. Raise your hand if you know one. Oh, Leon. Of course he knows. Okay, give me one difference.
The maximum fine.
Maximum fine. What's the maximum fine for part 1?
$1,000.
Correct. What's the maximum fine for part 3?
Jail.
Jail isn't a fine. Jail's a fine. Leon.
5,000.
No, there is no maximum fine under part 3. In fact, if you're doing a no insurance, the minimum fine is $5,000. So the trick question is there's no maximum. Okay, what's another one?
Question?
It's not a question, just the difference.
Oh, another difference?
Yes.
Like the part 1 is up to half a year in prison.
Nope.
No jail.
You cannot go to jail for a part 1. Section 12 of the Provincial Offences Act, and you read this section carefully because it's a big one that differentiates the two, limits the penalty that can be imposed. So the maximum penalty you can get is $1,000. No jail. They cannot impose a suspension, but in some cases, like novice driver violations, there are what we call hidden suspensions. So your G2 BAC above 0, G1 unaccompanied, those types of offenses, they will yield a 30-day suspension, but it's not like a drive suspend where in the arraignment they read it out. So while they cannot sentence you to a suspension, there still might be one. But the important thing is you cannot be sentenced to anything other than a fine and a maximum of $1,000. Okay, what's another difference? Okay, this is one of the. Oh yes.
It's just the appeal procedure as governance session is different for part 1 and part 3.
Okay. Yes, you are correct. That's a much more advanced one. You're not going to have to worry about that on your Law Society exam, whether it's a Section 116 or a Section 135 appeal. But yes, nonetheless, that is a correct answer. But if you're pointing that out, that tells me, you're good. You don't need to worry about your Law Society exam. Here's a big one. Limitation periods. Who knows them? Part 1, Part 3, what's limitation period? Yes?
For the Part 3, it would be normally 6 months, not
He
including,
qualified it properly, normally 6 months.
not including
So-
Compulsory Automobile Insurance Act charges, which is 2 years.
Right, we're going to talk about that because that's an important one, and that's one of the questions that will get by people. Okay, so the limitation for a Part 1 is 30 days, right? It's got to be served within 30 days. If it's under Part 3, generally, it's 6 months. But, like Bill pointed out, in cases of Compulsory Automobile Insurance Act, it's 3 years. So, there are statutes which define the limitation period for offenses contained within its statute. So, a question might be posed, Johnny's charged with no insurance, but it was from a year ago, they can, and it's going to be A, B, C, or D. And the answer is they could probably proceed. There's no, if it's within 3 years, they're okay.
I believe it's 2, is it not, or has that changed?
No, it's 3. It's been 3 since, well, at least 1990 since I've been doing it.
3, sorry.
What's another one?
Oh, Leon?
Part 1 has a set fine, Part 3s do not.
He's correct. Technically correct that a Part 1 offense.
So I didn't write that down.
Part 1 offenses have a set fine.
Yes.
Okay. Part 3 offenses do not. But Part 3s are issued a summons. They're given the defendant's given a summons. Correct? Does everyone agree with that? You don't know.
Yep.
You know?
Yes.
Okay.
So.
Can you get a summons under Part 1?
Yes.
Okay, I'm gonna put your hand.
Stop talking.
Can you get a summons under Part 1?
I don't know. I thought it was
Flip
offense
it.
notices.
Take a quarter. Flip it.
No. Yes.
The answer is yes.
Yes.
You can get a Part 1 summons. If anyone's seen York Region with their accidents, all their accident cases are Part 1 summons. So they're actually summoning everyone to court. So you can get a Part 1 summons. It's not going to be in your law side exam, but be very careful. Well, the fact that the guy's got of what's normally a Part 1 offense could be by a summons. They're probably not going to specify Part 1, Part 3. But if it's a Part 1, just general practice, seeing a rash of them lately that have both a set fine and a court date, and that's a huge problem. They're all getting quashed. But look for that, right? Don't think because there's a court date and the set fines there, it's not a notice of trial, right? It's a summons. So they're either giving him an out-of-court settlement or they're compelling him to come to court. They can't do both. They can't give you a fine to pay and then drag you to court to be sentenced, right? That ideally, the paying of the fine amounts to a guilty plea. Leon.
Yeah, that's also another difference you can put up there, is that the Part 1, you can resolve it by paying for it and see later, or Part 3, no, you gotta go to court at least twice.
Okay, so put Part 1, you can pay out of court. Yeah, you can pay your Part 3s in court too, actually, but you gotta get sentenced first. They actually gotta convict you first. Under Part 1, wait a minute. Why am I giving you the answers? Give me another difference. Think. How long ago did you guys do POA? Has anyone here not done POA?
Oh, okay.
Okay, you guys get a pass.
Let's just listen and write.
Just listen and write. So, no one else? Come on, you had the section 116, 135 answer.
Yeah, it's pretty good time.
Oh, I see. No, see, like your writing's much more.
Well, but they need to see. There you go.
Before I show the differences.
All right, so Part 1s are, the original charging document is called what? Bill?
Provincial offense notice.
No.
No.
Leon? Yes, sir. On a Part 3, what is the original court document called? Yeah, it's okay, Leon. We know you know. It's okay. You might as well just shout it out when you know. It's called a what? Begins with an I? Information. Yeah, was that you?
Yeah.
Okay.
Yay.
Not that like anyone's gonna really get the credit for the answer, except people in the room, but.
I cheered.
All right, and the defendant is given what, Bill?
Provincial offense notice, also known as a POT or provincial offense.
Right, it's called generally an offense notice or a provincial offenses notice, but now, a lot of people confuse the certificate, which is justice's copy, with the offense notice, defendant's copy. And I mean, you know, guys doing this as long as I have, say, oh, there's a mistake on the offense notice. It's, they mean to say the right thing, and I say it wrong half the time myself, so, you know.
The cop will usually call it a pawn.
Yes.
Yep.
Yeah. Okay, and what does the defendant get in the case of a Part 3? Now you know them, right? Summons, right.
Now I know it.
And as we already discussed in the case of Part 1s, occasionally, in some circumstances, a summons is going to be issued. Tell me what you think. Let's just brainstorm here, because this is some of the stuff you're going to have to be answering questions on. Someone's charged with a stop sign, regular stop sign, nothing out of the ordinary, did a rolling stop, we'll call it. Do they have to lay a Part 1 or a Part 3?
Sounds like it'd be a part one.
Okay,
Oh, why?
elaborate.
Because it's not really that serious.
Okay, so if you were the police officer, would you do a Part 1 or a Part 3?
Do a part one because it's easy. You don't have
Well-
to tie up court time to bring them in.
Especially if they just want to pay it, right?
Yeah.
Okay, what if they were really bad, had a horrible attitude, and just made your life miserable at the side of the road? And like you know, that if you gave a Part 3, you'd literally be dragging their butt to court.
Well, I guess I'd do it for it.
Okay, the answer is, there is no answer. They have a choice of doing a Part 1 or a Part 3. Now, in the facts I gave you, probably what's going to happen is, it'll just be a Part 1. But, what if?
Well, can you think of a situation where there'd be a rolling stop sign where a police officer would lay a part 3 instead of a part 1?
Sure.
Not you, not you. Yes, ma'am.
Maybe in a kid zone, school, if maybe they caused an accident.
Or give me a circumstance where they would probably do a Part 3, even on something simple.
Entering a highway.
No, that's not what I'm thinking of.
No, it's
The
not.
guy's a Hells Angels associate in the cop.
That'll come out.
How about prior? Okay, go ahead.
How about the cars just rolling towards the police officer, careless drive?
No, it's just a stop sign
It's
offense.
just a stop
There's
sign
nothing, you know, outside of the fact that it's just a stop sign offense.
History. Yeah.
Yes.
It depends how many times he's been charged with this already.
Prior record.
Prior record.
Right. They're doing a lot with cell phones, right? By the time you get your third cell phone, they're just doing Part 3s. So more and more we're seeing multiple offenses become Part 3s. Leon.
Or say there was a very, very serious aftermath such as death. You could be charged with Part 3 even if it's a stop sign.
Right. Yeah. If you want to hire, see, a Part 1 limits the penalty. Well, it's basically the set fine. So if they get a Part 1, they can simply pay the set fine. They don't have to go to court. They don't have to do anything. So if it's a serious case where someone was hurt, or they might do a Part 3. If the person has a prior record, they might do a Part 3. But, you know, it's just important. There's no right or wrong answer. Just think about when and why they would do either one of those. Yes?
Just an interesting question. Is there a maximum jail time for Part 3?
Generally, 6 months.
6 months, yeah.
You also have to consider, like 12(1)D under the Highway Traffic Act provides for a maximum penalty of 30 days jail. So not only do you have to consider what the POA, because the POA doesn't say what the maximum penalty for jail is, but the statute will limit what the penalty is. So it's important to look at the offense creating statute to see what it is.
And normally, when you're talking about an accident that could have serious aftermath and there would be a death, the police officer also has the discretion to lay a criminal charge. So if there's going to be a death, there's a good chance he doesn't want a Part 3 and he doesn't care. He's going to go further than that because there are more than that because they're going to deal with a family and everything else.
Yeah, if it's literally if you killed somebody, it's probably going to be a careless, not a stop sign, because you're really taking away. Yeah, you're taking away by laying the stop sign. You're actually taking away a lot of the penalty availability to the justice, right? You can't put them in jail. You can't suspend their license. You can't put them on probation. You can't, stop signs, absolute liability. The most they can do is give them a fine. So, but we see stupidity all the time.
I was going to ask, what would be a strictly Part 3 offense where you would get 6 months?
You tell me.
I have no idea.
Does anybody else know?
We're quizzing you to see if you know.
He's been doing it a long time.
Well, let's think of what kind of Part 3 offenses would attract a jail sentence. So, drive suspend is the most popular one. Careless. Those two are big ones. Stunt driving, you can get jail. So, those offenses, probably if it's a careless and it's a fatal, someone's dead and the family's loud enough, probably going to be jail.
Even if it's not charged criminally and just charged under
Yeah.
Part 3?
Yeah. And I don't know how this is being broadcast, but my experience, the louder the family, the worse the penalty, right? It's really hard. And you got them crying in the prosecutor's ear, and, it's easier just, anyway, we'll talk about that. But that's the correlation, isn't the seriousness of the offense.
Public interest.
Yeah, we'll call it public interest. Yeah, because the family is a member of the public.
Public interest.
All right, how many do we have? We have 1, 2, 3, 4, 5, 6, so many more. Okay, here's a scenario for you. And this, I may or may not know if this is on the law side exam, but I'm going to give you a scenario, and you're going to tell me. No, we don't want it publicly out there.
Okay.
Okay, so your client gets a careless driving ticket, right? And it's, he hits a pedestrian, the pedestrian's rushed to hospital, and then 3 days later, the pedestrian succumbs to their injuries and dies. So the police decide that Part 1 careless they just gave you isn't any good, and so they come back, and they now lay a Part 3 careless. You probably know this. Okay, what's the first thing you want to find out? Okay? I know that none of you are going to know this, except him. And he might not, actually, but I'm thinking about. What does the prosecution, what do they have to do this? Leon?
You have to get permission from the prosecution office.
Kinda. You're partly right.
You're almost there.
You're almost there.
Well, first of all, ask the question, can they do this? Start with,
Right.
can they do this?
Right.
Can they do this?
You can do it.
Okay.
But you're going to lose it. You will lose it in court. Because guys like you will come up and
See, that's the police answer. The legal answer is you cannot do it, and that's why you win it in court, is because they couldn't do it. Right? So the answer is to go from... Yeah.
So you were charged with a Part 1, which was what was he charged with?
Careless. So 400, 6 demerit points.
In a Part 1?
Yeah.
Yep.
And then somebody died, you said?
The
Or-
person,
After the
after the fact, they died, and now they realize, oh, we have a family to deal with. There's going to be a huge fallout from this. The penalty of $490 is too big a pill for the public to swallow, right? So we're going to do a Part 3 and let a judge decide what the appropriate penalty is.
On the guy you've already given a ticket to.
But he's already been charged with this exact same offense, only under Part 1. So by laying a Part 3, you're taking away all the safeguards they had under Part 1. Yes?
Now, couldn't they just drop the Part 1 and then recharge him secondarily with the Part 3? No?
Can they? Tell me.
Well, I'm thinking it depends because you have that limitation period.
No. There is a section, and a number, it's in the 20s, but whatever. Part 3, it's the section where Part 3 begins. You cannot issue, or you cannot lay a Part 3 where previously a Part 1 was laid without consent of the Attorney General or his or her agent. Now, be mindful of this, if not on your exam, then in practice. who that agent is important, because the Crown Attorneys Act defines who that agent can be, and you'll find that those provincial prosecutors who are giving consent don't have the authority. So, yes.
It happens all the time.
Right, and you need to be smart enough to know that that shouldn't happen. Plenty of convictions for illegal searches because people are too dumb to argue illegal search. Just because it happens doesn't mean it's okay, right? So what you need to do is to be on your game, is to be alive to that issue that, hey, a provincial prosecutor issued this, right?
And one of the ways to think about it too is that your normal instinct as a person is to think about punishing people who did something wrong. That's a normal instinct because that's the kind of society we live in. We want, oh my God, somebody did something wrong, we want to punish them. So your normal instinct to say, of course, now he killed a family, now we're just going to switch the charge or whatever. But put yourself in the defendant's shoes. Is it fair to him? That person who had a ticket for $400 and 6 demerit points now could potentially go to jail. Does that seem fair? So think about it the other way. And that's a whole mind shift. And that's not necessarily obvious because we have a tendency as a society to think, okay, let's punish, let's put these people away, let's make them pay money. So just always think, okay, but is it unfair on the other side? And look at the other side of your coin when you're thinking about those things. Okay, sometimes those are the trick questions. Sorry.
Just because the victim doesn't have the foresight to die at the accident.
Okay, but look, there's a 30-day. Why did he have to lay the ticket the day he showed up? Right? You don't have to lay the ticket there. So if you're too much in a rush to ticket these people, why is the defendant who's being charged being penalized?
Let's tweak the facts a little bit.
Can you just repeat that, said without consent of?
The Attorney General or his or her agent.
Or his or her agent.
And that has to be a Crown Attorney, by the way. Cannot be a, provincial prosecutor unless they happen to also be a Crown Attorney.
Realistically, though, aren't they just going to go as a dangerous driving under the code? And
If the injuries are serious enough.
Okay, we're going to get to that because we're going to merge that.
Yeah.
Here's a little caveat we're going to add to the facts. Before the person died, or after, it doesn't matter, but before they got the Part 3, they felt so bad they went online and paid it. Right? They paid the ticket. Right? Paying the fine is what? It's an admission of guilt. They've pled guilty to the charge. And then the police officer comes and gives them the exact same charge. Tell me what you would do.
I call Frank.
Well, technically, it's a malicious prosecution because you've already been.
No. You're actually way off on this one. There is a very specific thing you're going to argue. Yes.
I don't know. As you know, I'm not much of a POA guy in general, but I would have thought that you're getting close to like res judicata, like that type of concept.
You're closer than Leon.
You're closer than Leon, but you're
Yeah,
not
like
there.
you've been charged, you've paid it.
There's
so
a
the
concept
issue should
in
be done
law.
at that point, right?
I don't know what that Latin was, but isn't it the double jeopardy? You've gotten your sentence.
What's the word? What's the Latin word? Give us an A.
No, I don't know.
Autrefois.
Yeah.
Can you spell that? It's A-U-T.
Oh, it's autrefois. Because it's a
You can
French
even say it
switch.
better because you're.
Autrefois.
Convie or acquis. So you're arguing that they've already previously been convicted or they've previously been acquitted, right? So when your guy paid that fine, they couldn't prosecute anymore. Forget the consent issue. Let's assume they got consent. They still can't proceed under Part 3 because they've already been convicted of that exact same offense. And Pineapple and Prince, there's a legal nexus. It's more Pineapple than Pineapple, actually. So
what you're saying is that if you get dinged for Part 1 and you find out you killed somebody, you go pay that ticket right away?
No, I'd still go.
I'd still go to trial.
But these are some of the things you got to think about because the question you get might be, let's see if you're aware of some basic first principles and that we don't convict people twice, right? We don't do that.
Because it would be unfair, right?
Okay, so where are we here? Jeopardy. We didn't. There's more differences between Demerit points will not be on an exam. And they suck and they don't affect insurance. Nobody cares. So, you know, when clients ask me about demerit points, they say, why? Why do you care? Like, okay, so we'll just leave that at that for the differences because I'm cognizant of the time. It's 7:55. We should be talking about some of the general POA stuff if you are going to be doing POA defense work. If you're a prosecutor, I don't care. Your ethics will be, you'll have a mentor, you'll have someone train you. But if you're doing defense work, I'm going to give you 3 words. 4. Defend your bloody client. Okay, so here's a scenario. Guy comes in your office, he's got a 20 over. What do you tell him?
Slow down.
Should be cut the check if you're going to
Yeah,
sit. But
if you're
anyway,
gonna sit, cut the check, yeah.
what do you tell him? I will defend you. But you'd be amazed. I asked that question. A lot of people say, "Oh, I can probably get it reduced to 15 over." Right. So let's just understand very briefly how your insurance works. Is risk assessment. So your insurance company doesn't care if it's 15 or 20. The MTO cares. Your insurance won't care. Right. A minor offense is a minor offense. So you need to understand what your clients. The policy that they're currently under, because they vary. Generally, anything up to a 30, 35 over is considered a minor offense. So, be aware of that. So, I don't care if it's a 20 over, I'm probably going to go to trial. There's no savings in a 15 or a lesser fine, and there's no demerit points, but those points don't affect their insurances, which is why they hired me in the first place. So, be aware of that. Well, I see every day, everyone with like a 29 or less pleading to a 15, and their clients are happy because they don't even realize they haven't saved anything. Danielle prosecuted part 1's, probably happy to take the 15 over plea.
Absolutely.
Because, how much work do you have to do in a guilty plea versus a trial, right? You'll probably get them if you prosecute them, right?
More than likely.
Right. But remember this, if you have the trial, you'll be convicted maybe. If you plead guilty, you're getting convicted for sure.
And a 15 over to that specific ticket on that specific day doesn't really have necessarily any significance because, like Frank said, it's a 15 over with 0 points and it's a very minimal fine. But if you don't discuss with your client, do you have a prior? Do you have 6 other ones on your record? Do you drive a commercial motor vehicle? There's all kinds of other considerations. So when you actually are going to defend this person, it could be a bigger deal than just a 20 over. So that's why Frank is like, your first approach is I'll defend you. Let me look at everything and figure out what's the best strategy.
Yeah, you might end up pleading to 15.
Exactly.
Right? Especially you discover the guy's got 12 points. Right? So how many for suspension? 15 if you're a G licensed driver, which means 3 more points and you're suspended. Then you're going to do everything you can to get to 15, which may now be a challenge because he's got 12 points. He's got priors, right? So, you have to take the approach that protects the client. Right? You're always must protect the client. And every law society question you're going to have in some way is going to be asking you how you would protect the client. And a lot of those questions are, could hurt you. You made a mistake. You should do what, right? The answer that best protects the client, that communicates with them, is always going to be the correct answer. You're never going to have one that says, well, just try and reopen it and hope they don't find out. That's never going to be an answer.
Forge their affidavit.
Yes.
Forge their affidavit.
You guys laugh. We know.
You laugh. I'm giving
we know
you
2 people.
examples of things.
Yeah.
Pretend to be somebody else when you're in court. What? Yeah, these
Oh
are.
my God.
I'm just putting it out there.
That's crazy. I heard that story when someone told me, I said, he wouldn't do that.
Yep.
Guy was administratively suspended by LSUC. Goes to court, and he said he was someone else. And
Who was also administratively suspended.
who
was actually there for counsel. So
I
we'll
think if I remember the story correct, the prosecutor might have known the person they said they were.
Exactly.
I'm like, what? You're not what?
You don't even look like that guy. What?
So remember, it's every question you're going to have, even substantive questions, have an ethical component to it. So it's important that you remember it's all about the client. You pay your Law Society fees, but their mandate is not to protect you. Their mandate is to protect the public. Yes. Oh, sorry, I thought you were raising your hand. So the girl behind you is playing with her hair, and I thought you were raising your hand. So.
And any question you're going to get on your LSAC exam, that's always going to be a big thing, right?
Yeah, I can't read lips.
It's going, the ethical component is always super important, and it's super important to the Law Society because that's what they're suspending people for, that's what they're fining people for, you have to be above board. So when you read the question, like Frank said, just make sure it's whatever's best for that person, that member of the public, that person that doesn't know, because you're the expert, you're the legal representative.
Okay, Lori,
Just going to interrupt you for one moment to announce the raffle, and then I'll let you keep going. Okay, second winner of the raffle can contact Christina McDonald or Frank. Call Christina. Call Christina. Law Society prep course, and that is Lillian Russell.
Oh,
Okay, 8:30. You're cut off.
All right. What were we just talking about?
Ethics.
Ethics.
We were talking about ethics.
There was something about it. I wanted to stream into Crims. I don't remember. That's okay, because it'll, like,
Come back up.
the thought will just pop up in the middle of something else, and then I'll be like, oh yeah, I remember! Right. Okay, so it's a little after 8 o'clock, so we should probably start discussing criminal. A lot of the concepts you're going to do in POA are going to just spill over into criminal, because POA is born of criminal, right? So you're going to have an actus reus, you're going to have you might not have a mens rea necessarily in POA, but yes?
I'm going to tell you, the last 2 exams, the feedback I have received from over 90% of the people who have written is criminal POA and really, really, really stressful and tough in those areas.
Yeah, no, we have good intel on it's on the exam. Okay, so what we do is when we do a prep course, we ask everyone, try to remember 5 questions. And then we keep getting all these questions from them, and we've compiled the list. And there's a fairly big emphasis on criminal with peace bonds. And a lot of the, although a lot of people confuse some of the evidentiary type questions, like when you can talk to a witness, when you can't talk to a witness, that applies to everything, right? Whether it's small claims court, LTB, POA, crim, it's all the same stuff. The rules on witnesses don't change because you're somewhere else, right? So anyway, criminal. Okay, so what you really need to know, what LSOC is going to be looking for, is whether you know what you can and can't do. Right? So who can tell me, in the context of paralegal criminal work, what can you do?
Summary conviction.
Define it more narrowly for me. No! Drive off!
6 months or less in jail and $5,000.
That's it. $5,000 fine and 6 months jail. Okay, so here's a scenario for you. Joe accused is charged with impaired driving. He gets a charge screening form, and the prosecution is asking for a $1,000 fine and the mandatory 1-year driving prohibition. The fine's only $1,000. They're not asking for jail. Can you do this case? No, Leon, you already know this, buddy. Give him a fighting chance, man.
That's something else.
Okay, say it again. Sorry.
Slowly.
Okay, so he's charged with impaired driving.
Okay.
Right? Now, they're only asking for a $1,000 fine, no jail, and they're asking for the 1-year driving prohibition. Although, whether they're asking for that prohibition or not doesn't matter, because it follows the conviction. Right? So they're asking for $1,000. Can you do it?
No.
And why?
Who said no?
You cannot.
You cannot.
And
Okay.
why not?
Because it's a super summary.
What does super summary mean?
18 months.
Okay, so he's correct.
Is it all together? I don't even know.
Who cares?
Okay.
Who cares?
This doesn't exist where I'm from. So.
Yeah. So, Well, super summary was a coined term. It wasn't actually, it doesn't say super summary in the criminal code. Criminal code just says summary, but it actually specifies some offenses that have a maximum penalty of 18 months and some 6 months. Super summary is...
Background. Why does this exist, Frank? Why does super summary offenses exist, Frank?
Okay, so prior to 2008, and a little after when this passed, a lot of paralegals thought it was to keep us out of some offenses. It gave a judge more powers on sentencing without having to kick it up to... See, before, it was either summary or indictment. And indictment, you had a right to trial by a judge and jury. So it's a lot of money you're spending for a prelim, for a trial, and it's on just an impaired. So what they did was they increased the penalty. That way it would stay in provincial court. Before super summary came along, there was a term called absolute jurisdiction. And those were offenses that you could proceed by indictment, but regardless, they would stay in provincial court. So super summary is more, I don't say modern now because it's like 9 years ago, but it was an easier approach to offenses which were indictment, and there were lawyers who didn't know that they couldn't go to superior court because they were absolute jurisdiction offenses. So super summary is the new moniker which we use for that.
Just be mindful, and I'm just going to put that out there because I'm from the East Coast, so I just have to put the East Coast component with regards to this. This terminology, this super summary, as Frank said, is not in the criminal code. It doesn't exist anywhere else. The coin terminology doesn't exist because we don't have paralegals that come to court. So that's not an issue. So nobody comes up with super. So we still have absolute jurisdiction in other parts of Canada. The first time I ever heard this, I'd been a Crown for 6 years. I'd never heard this word. I'm like, did they amend the criminal code? Nobody told me. So this is here. So if you ever get a question or a weird question that says like, oh, is this in the criminal code or does this exist? It doesn't, okay? It's an Ontario thing.
Yeah,
so
we still have absolute jurisdiction here. Super summary just means
we just don't.
offense by summary conviction where the penalty is more than 6 months. They could technically change something to 24 months or whatever, and as long as they define it as a summary conviction offense. The important thing for you is you can't do where the maximum penalty exceeds these two things. Okay, so let's talk about a couple issues which will come up, both probably on your exam and in practice. You are approached by a guy with a theft under, it's a hybrid offense, and you're not sure if you can act. You go to court, they give you a charge screening form, and the charge screening form says that they're offering him diversion, they're proceeding by summary conviction. Can you act?
No.
Who said no? Why not?
Because the charge screening form is not final, because you still have to wait to the court.
Wrong! Well, you're correct. Okay, so let's talk about undertakings. Okay? And this is on the exam. You, as a licensee, can rely on an undertaking of another licensee. Right? So undertakings are not like contracts. They're like very strong promises. If you give an undertaking, you are bound to follow it. So it is true that a charge screening form is not an election, but it is an undertaking. And you can rely on that undertaking. In fact, you should be able to rely on any communication by the licensee, but specifically charge screening form. Now, again, like everything else, there's a caveat to that. Let's assume, for argument's sake, that after they screened this charge, they discovered the guy had a 5-page record for property and crimes of dishonesty. And they send you a screening form that says, hey, new information has come to light, we're amending our election, we're going to proceed by indictment. Can they do that?
Yes.
Yes.
Yes, they can.
Yes, they can. Yes. So what would you do? Yep.
You just have to contact a lawyer and ask the case, but can you still work under the lawyer's supervision but not go to court?
It appears as agent on set dates is pretty much as you're going to do.
But you have to have a lawyer in file.
Yeah, basically you can't open the file. It becomes the lawyer's file, and if he wants to hire you to do some stuff on it, that's good. But in the context of holding a paralegal license, you're dealing with everything in the context of unsupervised work, right? So you're independent of a lawyer. if he wants to get you to go to set date court, if he wants you to review disclosure, draft applications on it, that's fine. But it's his name going on it, and when you appear, you're appearing for him, her, or, you know. So, yeah, they can change it. There are some implications for, we'll just say bail. Okay, so did you guys study bail? Probably not. You did? Okay, so who knows what crown onus, reverse onus for bail is? You know? Yeah?
Well, normally the Crown needs to prove why they shouldn't grant bail, but then reverse onus is when the defendant needs to prove why they should.
Where does it shift?
Murder.
Well, murder is actually automatic
And if
detention
you
order.
commit another something.
Right, murder is automatic detention order.
Yeah.
You can only be released by Superior Court, but you're never going to have to worry about that because it's way out of your scope of practice. Alex.
It shifts if, for example, you were on bail and you breached the bail, you're back in court, and now you have to prove why you have to go.
That is one circumstance of reverse onus. But what if, okay, I'll give you a scenario. You go to court and the prosecutor sees the charge screening form, your client's not there, and they do you a favor and they elect by summary conviction, and then your client commits another theft while out on his, we'll just say, Form 9. What are the implications for bail?
That you reoffend and you're a danger to the public.
Not a danger to the public if you shoplift twice, but...
But I mean, that's what they say. That's what the procedure
There's a
is.
legal implication for bail. Okay, Danielle?
The legal implications of reverse illness.
Well, if they've elected summarily, he's
Oh, they
not
did-
facing an indictable offense. If they've actually elected, not on a screening form where they
Actually elected on the record.
if they've actually elected on the record and he's facing a summary conviction offense, then is it crown onus on that second theft or is it reverse onus? Why is it reverse? He's released on a Form 9.
Because one of the, it's under secondary grounds.
Forget your police policy manual. I want you to tell me about in the courtroom, you're in front of a justice of the peace saying, my guy is not facing any real jeopardy. Who's read the most recent Supreme Court of Canada case on bail, by the way? Just saying. Yeah, I know you would have read it. We know where they stand on bail right now. So if it's a hybrid, it's deemed indictable, it's going to be reverse onus next time around. Doesn't matter how good or how bad the facts are, it's going to be reverse onus. But if they've elected on the record and it's basically a screen for diversion kind of case, is it reverse onus?
I would say no unless this new case has changed that. I was under the impression it was an indictable, but I don't.
It's
practice.
deemed indictable. Hybrid offenses are deemed indictable until such time
Until an election was made.
an election is made.
Then once the election's made, it's a summary offense.
Right.
Oh, so you're
So
asking
that-
if they're then
Correct.
arrested for a hybrid. Oh, so I would say yes, for sure.
Yes, what?
Yes, that would be a reverse offense.
Yeah.
Did everybody follow that?
Yeah, because it's considered indictable.
Or do you
until the election.
have to be? No, it's not, because it has to be an indictable offense, and then you're also arrested again for another indictable offense. The first one was
The
a
difficulty
summary,
is
and
thinking about it in a practical,
Yeah.
like, it's crown onus is the answer, right? If they've actually elected, if you're on a Form 9 and you got them to elect on the record, it's crown onus. If they haven't elected, you're on trial with an outstanding charge of a deemed indictable offense, and it's now reverse onus. So that election makes a difference. Right.
And that's why a lot of the times when you do see those things, the Crown will take its time before making the election to reserve that power.
That's right.
Because we know they're going to come back and reoffend because sometimes we've got police intel and we know they're coming back. So we'll go, we're just going to withhold election. We're going to wait a couple
What was
weeks.
that Blatchford article I just read today, where it says they give the alcoholic shoplifter conditions they can't follow, like don't
can't
drink
drink.
and don't
They all
steal.
come back.
So, all right. So it's important for you to know what you can and can't do and some of the implications of it. So it's important, and you're going to get this, where they say, well, we haven't elected. We've screened it for somebody, but we haven't elected yet. And Crown attorneys don't deal with LSUC. They don't deal with clients. They can make whatever decisions they need. They don't need to go to a client and get instructions. Okay? It's basically I can do whatever the heck I want as long as it's within my policy guidelines. So They don't think of this stuff.
In the public interest, Frank.
Whatever. Public interest. So you know what? This is public. I'll save the story for the bar. Yeah, we'll save it for the bar. Okay.
What about designations of council, Frank?
We don't do those. Stop. If anyone ever does a designation of council, you're not council, you have a problem.
Be very careful.
Not only are you committing an offense, but you're giving them documentary evidence you committed it, so stop it.
And I've seen quite a few, I even saw some this week, where it says, the top of it says designation of counsel, and then the bottom says paralegal of record. And I'm looking at the page going, really? Like,
You have a good mens rea defense. I disclosed I was a paralegal, I don't know.
So just be careful, okay? So if a lawyer if you end up working for a lawyer on an indictable or anything, you cannot sign that designation of counsel. No matter if they tell you you can, you can't. So keep that in mind too.
We're just going to talk really quickly about forms of release. Okay, so as a paralegal, what forms of release should you be looking for? Leon?
Form 9, Form 10.
Form 9, which is called a what?
Appearance notice.
Appearance notice, right. Form 9 appearance notice, you're probably golden. Form 10, which is A, begins with a P, promise to appear. And there may be a form, what's the next one?
Officer in charge undertaking.
There you go. What, number 11?
I don't know their numbers.
Form 10 is a promise to appear. And then Form 11 is the undertaking before an officer in
Oh,
charge.
yes, okay.
It's where the police can give conditions on
I
those.
know what they're called, I just don't know what the number are.
Now, if you have a client who shows up with a purple or pink bail paper in their hand, what should this tip you off to? Really? They held him. They had to hold a bail hearing. They had to release him. Like, he wasn't released from a police station. He's got a judicial interim release form in his hand. What does that tell you? Probably it's something that is outside your scope of practice. So be very aware that if a guy comes to you with a bail paper, not a little blue Form 9 or, a little white Form 10 or Form 11, but he's got the pink bail paper in his hand, that should be like a Danger Will Robinson alarm going off in your head. Okay, witnesses, we'll skip them. This is something I want to cover. I always forget. I'll remember at the bar. It's okay.
That's a PT, that's what I was gonna ask them.
Taking. Oh yeah, this was right.
You get those wrong?
Yeah, no, sorry, you're right. Comes to appear, undertaking. This is correct.
49's or what?
Oh, appearance notice.
Oh.
It's like a criminal version of a Form 104.
Yeah, I've never seen this because I did that.
Frank, how about what if you absolutely need before you can enter a plea for a client?
Money.
Disclosure.
You need, guilty pleas have to be informed. What does that mean? What does it mean to be
I was
informed?
going to answer, or was it
Go ahead.
disclosure?
Sure, but, disclosure is part of being informed.
Yeah.
Right?
Your client needs to know that the judge may not accept any plea agreement, may in fact impose a greater sentence than that which was agreed.
Not propose, impose.
Impose.
But yes, absolutely. Generally, for a plea to be informed, they must be aware of what they're pleading guilty to. They must be doing so voluntarily. No one's put any pressure or forced them to do it. They're doing it of their own free will. They have to admit the facts of what they're pleading guilty to. They don't have to admit every single fact that's read out, but just enough that would support a conviction on the charge. And they must know that the justice is not bound by any joint submission.
And if you forget all of what he just said, is there a place where you could find this?
Yes. It's like the devil's number, but the middle one's different.
Exactly.
6 something 6.
Really? Like,
Amazing, amazing.
That's exactly what I said, though.
Just in numbers, yes.
I said it.
6? What 6?
1, 2, 3, 4, 5, 6, 7, 8, 9.
6, 2, 6, 2.
If you begin with a 1,
You're already too far.
you're already too far.
0.
So 606. So sometimes you'll be in court and the judge will ask you, have you done 606 with your client? That's what they're talking about. Have you informed your client? Have you told them what they're pleading guilty to? Are they aware of the facts? Are they aware of what the Crown is seeking? Are they know that I'm not joined? But they're not going to do all that because it's really busy. So they're going to go, counsel or paralegal, have you done 606 with your client? Okay, but that's what they're talking about.
So I'm going to tell you a story. This is a true story. A friend of mine He was a police officer, then he was a prosecutor, and then he was doing defense work. And he had a client he was defending on nothing more than a failed surrender insurance card. And he had this brilliant idea one day. He thought he was doing everything so perfect. He called the Law Society and said, come audit me. And so, and they said, pick any 5 files. So he picked the 5 easiest files. Of course, one of them is this failed to surrender. And he didn't order disclosure. And they said, hey, we noticed you didn't order disclosure. Why not? And he said, just a failed to surrender. They're like, yeah, so? They have to disclose their case. Why would you deal with this case without, maybe the officer lost his notes. Maybe something happened. Maybe, there's something you could do to actually defend your client. And he was dumbfounded. He was like, what? But I can just look at the ticket. I know exactly what he's going to say. Like, you know what you think he's going to say. And it turns out, if you look at the client's version of events, he actually had the insurance card. The police officer gave him 30 seconds to produce it, and he couldn't produce it in the 30 seconds. So it's questionable whether it was a slam dunk conviction. Right? So, when we talk about 606 and making sure you've crossed these, that's okay. Remember, the Law Society is all about public protection. Right? So protect your client. Make sure that if they're going to plead guilty, they're going to give something up. They know all the stuff in 606. Right? And even in something so simple, like a fail to surrender, that you think, well, it's a $50 fine, who cares? They're actually all about the client. They're saying, probably he's going to get convicted. Probably they're going to give you police notes. Probably they're going to say they asked for it and he couldn't provide it. Probably this will be the way you think it is. But you don't cut corners that could affect the client just because you think it's probably going to end up a certain way. Right? And you had your hand up?
I did. I just wanted to mention, I liked your tack before, that I know it's not formally part of the 606, but to make sure your client is fully aware of all the implications, not just the formalized legal ones, but do you drive a commercial vehicle, you've gone through any possible hits to their insurance, the practical financial business applications that could come from that. I know it's not...
If the one reason you're going to do it is this. Forget the client. It's a Law Society job to protect the client, right? I mean, it's yours, but it's Law Society. Here's the thing. On appeal, right, when his insurance goes up or when something happens and they're going to get a transcript of that proceeding, right, you're going to want something that demonstrates you said they're not bound by a joint, that he's breathing substantially, there's no pressure, he's doing it so voluntarily, he's waiving his right to trial, So, good practice is to have plea instructions, get them to sign off on it, right? And if there's special facts to your client that are going to affect him differently than everyone else, like he drives a commercial vehicle, CVR implications, if you have his record and you know that this guilty plea is going to end up in a suspension or something, it should also be in there because that judge hearing the plea will not know this, right? If you're pleading your guy to a 3-point offense from careless, say, and he's got 12 points already, he's getting a 30-day suspension, right? If he's a truck driver, you've just take him out of the game for a month. That should be part of informed, right? They need to know about everything that affects them, not just, don't worry, it's 3 points. It's, $85, a couple of court costs, 110 in total, and it's a minor to your insurance. So we're good.
Another thing that comes up too that might be important for you guys that we used to see a lot, I don't know if it's still the case when I did POA, is that your client who's hired you and you've done the best job, and Frank included does the best job and has all these plea instructions, and their grounds of appeal is ineffective representation, bad legal representation, ineffective counsel, bad paralegal, whatever. If you've got those instructions and you've actually sat down and go through and you've memoed your file and said, I brought so-and-so in on this date. We discussed the motor vehicle implications. We discussed all that. It's a whole lot easier to get out of an appeal when we, as the prosecutor, will say, hey, Frank, can I have your affidavit that says what you discussed with the client before?
Yeah, confidentiality still applies, but when they go to appeal and say you entered this plea without their permission or the plea wasn't informed or something, the first thing you do is you take that plea authorization and you give it to the prosecutor, and you're allowed to do that to protect yourself, right? You're not telling the prosecutor what the client told you. You can't do that. But this very limited plea instructions, this one sheet of paper that outlines everything, is good enough. Here you go. Done deal. And that'll save you a lot of hurt. So does anyone have any questions? Because I'm mindful of the time. It's 8:25. Yeah, no questions? We're good? Everyone knows everything? You ready to rock your exam? That's it? Give me your pencil, start circling letters. So if I can leave you with any, general information about the exam, it's all about time management, right? You have 90 seconds per question. That's a lot of time. You're not going to need that much time. And every time you answer a question with less than 90 seconds, you're actually adding time to the remaining questions that are coming. So the best thing you can do is know your core information, know your basics, tab and highlight the crap out of your materials. Know and be able to locate information quickly. Now, I don't mean take a highlighter and highlight the entire book, because that's, but use like yellow for one thing, pink for something else. Use little post-it tabs, and be prepared to lose it, because you have to leave it at the test center. You can't bring it back with you. People say, why? I spent so much work. I'll tell you why. They don't want you writing down the questions and then bringing them to tell me, right? So you have to leave everything there. But that's it. It's time management. Bank your time. Tab your materials. If you can do all that, you're going to be okay. The test is long. It's not hard.
Okay, I'd like to thank everyone for attending online and everyone for attending in person. Again, the social that we're going to is General Pub and Grill at 21 Salina Street in Oshawa. So hopefully we'll see you there, and good night.
We're going to walk to the car right now.
Frank, you'll be there? Hey, can I talk to you for 2 seconds?
Thanks, guys on the bridge. Jason, Brian, and pop this up on video.
Like you can write for the next session. One of the other things I did a tutoring course